police where they went, by car, on foot, what have you. That's not legal provocation, and it would be error and frankly promote a miscarriage of justice if the state were allowed to argue that to this jury.
There is a separate instruction regarding whether or not there's unlawful activity. We're not asking the court to instruct the jury that wearing a hoodie and walking in the rain is also lawful activity. There is a separate instruction altogether.
We're not there yet.
I understand. Here we're talking about whether or not the totality of the circumstances.
We're still under the 776.041.
Yes.
And the defense doesn't want it, the state does. The court is not going to give it. The next paragraph in the defense version starts with, however, before you can find George Zimmerman initially provoked. That's in the defense version. It's not in the state's version. Do you want to talk about that?
Well, my understanding is, from what I'd heard before, that it's only there in the defense version.
Because of 776.
Because of 774.041. So if the court is giving none of that, I would assume they don't want that in there either.
Then we go to the next one in the defense is, you are further instructed that merely following Trayvon Martin by car or on foot in order to report his location to the police is not sufficient for you to find that George Zimmerman provoked the use of force against himself by Trayvon Martin. Before George Zimmerman can be found to have initially provoked use of force against himself, George Zimmerman must have used actual force or the threat of force against Trayvon Martin.
I think that's the same issue.
So all of that comes out too, is that correct?
It was all part of the extended.
Just making sure we get everything here.
Right, Judge.
The next one is a paragraph that says, in deciding whether George Zimmerman was justified. I don't see any differences in those paragraphs. Am I correct?
Yes.
That's acceptable to both sides?
So is the next paragraph.
Well, on the next paragraph, interestingly enough, both of you did not follow tally and take out the comma. And cases have been reversed because of that infamous comma after the words including deadly force. That comma should be removed based upon tally versus state at 106, Southern 3rd, 1015. Do we agree?
I agree. I'll remove it.
Okay, so that comma, do you agree, Mr. West?
That would read, stand his ground and meet force with force, omit the comma.
No, that comma stays in.
Oh.
The including deadly force, that comma comes out.
Oh, sure, that's fine.
Do both sides agree with that?
Yes, Your Honor.
Do you agree that that complies with tally?
I do.
Okay. So there's no other issues in that paragraph. The next one in the defense version is, you are hereby instructed that following someone by car or on foot in order to report their whereabouts to the police is not unlawful activity under Florida law. What case law or statute or anything do you have that supports that requested instruction, Mr. West?
It is an accurate statement of the law.
Show me where that's codified.
Well, in this instance, it's sort of codified by absence, in the sense that there is no criminal statute that criminalizes the act of following someone on foot or by car.
Well, you're free to argue that, but I don't think that should be included in the law that the court gives to the jury.
That's our theory of defense.
And you can argue it.
Well, I'm asking for an instruction as part of our theory of defense because, and I think this is critically important because of the facts of this case. Thinking back to jury selection, knowing what the court knows about the way this case has been presented in the media long before that, somehow, and last night I heard people talking about this critical issue of if George Zimmerman was following Trayvon Martin, then he's guilty of something. And that's just not true. If this jury were allowed to think for a second that following Trayvon Martin is illegal, they're going to think that he committed some sort of unlawful activity under the instruction above it that the court is going to say. We know already that Mr. Manti and Mr. Della Rionda want to suggest to this jury that somehow the act of following Trayvon Martin was illegal. It wasn't. It can't, and the jury absolutely has to know that, and they absolutely have to know it from this court. Otherwise, just arguing it doesn't make it so, and it would be misleading to the jury. It would confuse the jury on an issue for which there needs be no confusion whatsoever. The standard instruction says if Mr. Zimmerman was not engaged in an unlawful activity and was attacked in any place where he had the right to be, he had no duty to retreat and had the right to stand his ground, etc., etc. For the state to be allowed to suggest that by following Trayvon Martin in the car or on foot, that in and of itself suggests unlawful activity is absolutely wrong. It's absolutely would be a misstatement of the law. It would be a factual distortion that would lead to an improper verdict. So it's our theory of defense. It's a proper statement of the law. And if you want us to tweak the language a little bit, that's different. But as our theory of defense, we want this jury told by this court it's not illegal to follow somebody, especially if you're doing it to tell the police where this person went.
Response?
As the state objects, we would note that it's the first time I've ever heard unnamed media commentary cited as legal authority to the court. I would submit that while following itself might not be illegal, that following is one factor that the jury is free to consider in this case. It is something that evinces the defendant's state of mind. It doesn't have to be illegal, and I don't think the instruction, if we want to talk about what confuses the jury, when the court starts telling them things like it is not illegal to walk across the street, it is not illegal to walk home from 7-Eleven in the rain wearing a hoodie, it is not illegal to be armed with a pack of Skittles, that tends to confuse the jury. It is also inappropriate for the court. Basically, this requested instruction is a demand for judicial notice of a fact in question in the case to be communicated and given the imprimatur of a jury instruction to the jury. The state contends that it is not legally proper to request that we object to any format of this, tweaked or otherwise.
Ask the state to produce the Florida statute that makes it illegal to follow somebody. And then I'm
You're
good with that.
asking him to prove negative, basically. And
No,
so my question to you is show me a Florida statute that says that this is the law in the state of Florida. You're asking me to put in here is not unlawful activity. And under Florida law, you can argue that to the jury in the closing argument.
Judge, Detective Serino said so in his testimony. Any law enforcement officer...
Well, as far as I know, I don't think that he drafted any of the legislation.
Mr. Manti didn't say it was illegal to follow someone. He can't cite you. You know, criminal statutes are pretty precise. They're designed to put people on notice what's illegal and what isn't. So if it's illegal to follow somebody, to tell the police where they're going, there better be a law against it. Otherwise, you can't say it's illegal to do that.
Repeating your argument. I've heard the argument from both sides. I am not giving that instruction.
We submit that's an integral part of our theory of defense, and the court commits error by not instructing the law, this jury properly on the law.
I understand. I've already ruled, and you continually disagree with this court every time I make a ruling. I have provided you on 3 separate occasions with the court's professional conduct in the courtroom, and included in that is do not continue to argue with the court after we've ruled. If I have made a mistake in this case, you will appeal. If there is a conviction, it will get appealed to a higher court, and they can review it to determine whether or not I made a mistake. This is my ruling on this issue. You are free to communicate that to the jury in your closing argument. I am not instructing them on that. Moving on to the next.
I would like,
moving
though,
on.
I'm not disagreeing. I would like, though, to move in limine at this time with regard to Mr. Della Rionda or Mr. Guy or Mr. Manti's anticipated closing argument to ask the court to order them not to suggest to the jury that following somebody on foot.
Okay. Do you want
or-
me to get into getting a predetermined transcript of what each side intends to argue at closing argument and go through it and say what can and cannot be argued?
No, ma'am,
They're
just-
free to argue that.
No, ma'am, just this, that it would be an improper argument of the law if the state were allowed to suggest to this jury that it is unlawful for someone to follow another individual by car or on foot. And
I'm not
for the
going to
state
address
to
that
be
issue.
allowed to make that argument would mislead the jury as to the law and would allow the jury to make a decision based upon an improper legal premise, because the state can't make that argument legally, and I'm moving in limine now for the court to preclude that specific argument, and I understand the court's ruling as to the instruction.
Okay, your motion in limine is denied. The next portion of the instruction is the paragraph, and I'm going off of the defendant's suggested instruction. It starts at, "In considering the issue." There doesn't seem to be any objection or difference in that paragraph. Am I correct?
I believe so, Your Honor, and the next one as well.
Okay, and the next one is, if in your consideration of the issue of self-defense, it's a 3-line paragraph, there doesn't seem to be any differences. Is there any objections to that paragraph?
Not from the state.
No, I think that's the standard language now.
Okay, thank you. And then the last one, it starts with however. If from the evidence, it's 3 lines. Is there any objections from the state,
No, Your Honor.
from the defense?
Agreed, that's the standard language.
Okay, so I think we have, were there any other requested changes or additions to this instruction by the state?
As it relates to the justifiable use of deadly force,
Correct.
again, having already argued and simply relying again on the case of Johnson versus State, which is also in the packet regarding the provocation instruction, no, Your Honor.
Okay, any others being requested by the defense other than the ones I've already ruled on?
Within the justifiable use instruction?
Yes, sir.
No, Your Honor.
Okay, then the next one that we have, the defense has another one, you just included in your packet the state's proposed instruction on justifiable use, is that
I
correct?
did, just for comparison purposes.
Okay, thank you. Then there is a circumstantial evidence requested instruction from the defense. Is there any objection by the state?
There is, Your Honor.
All
I've
right.
provided the case of Wadman, W-A-D-M-A-N versus State, which is 750 Southern 2nd, 655. It's a 1999 opinion from the 4th DCA citing to the 1981 opinion of the Florida Supreme Court in re standard jury instructions in criminal cases, 431 Southern 2nd, 594. The instruction requested here by the defense has been eliminated by the Supreme Court. It was eliminated over 30 years ago, and the reason it was eliminated, as Wadman makes clear on page 2 of the opinion at the bottom, the Supreme Court deleted this instruction from the standard instructions, finding that where the jury is properly instructed on the standard of reasonable doubt, the circumstantial evidence instruction was confusing and incorrect. The court does go on to say that while the Supreme Court did not totally prohibit it, if the court in a particular unique case believes that it is necessary under peculiar facts to give, that a court could consider this as a special instruction, theoretically. However, they go on to catalog a litany of cases whereby the refusal to give such an instruction has been upheld. At the bottom of that page, head notes 2, 3, and 4, trial court should not give instructions which are confusing, contradictory, or misleading. And if I go beyond that for a moment, the court's opinion also issued an order on rehearing, which is found on page 3. And what the court said at the very end of the bottom of the second column regarding it is read in conjunction with the portions of the instructions that intent is an element of a crime that must be proven beyond a reasonable doubt. There is little risk that the standard instructions will diminish the state's burden of proof. And so the state objects to this instruction. We agree with the 30 years of precedent that have concluded it is confusing and incorrect. We don't believe that this is anywhere close to the peculiar case warranting the court even exercising a discretionary decision to give it. And I'll stop there until I hear more.
Okay. Mr. West?
Yes, Judge, thank you. I actually remember when this instruction was part of the standards. As Mr. Manti points out, that was some time ago. And generally speaking, the position the courts have taken is that a specific instruction on circumstantial evidence is not necessary because of the other instructions that the jury gets in terms of how to evaluate evidence. And they're told about circumstantial and direct evidence, but circumstantial isn't defined very particularly. However, when a case is appropriate for it, it's clear that the law allows it. The Supreme Court could have easily said at any point in time, you can't give it. If you give it, it's error. They haven't done that. What they've done instead, what has happened since, if you will, is that if the court thinks it's appropriate in a given case, because of the somewhat unique circumstances of that case, it is entirely proper to give the instruction. So knowing that it is proper, in some cases, I'd like to speak for a moment about why it's proper in this case. Since if the court gives it, it's not error. If the court denies it, it's probably not reversible error, unless a reviewing court finds that, in fact, this is that case, the case where it's specific enough as applied that it should have been given. So that's sort of the standard that we're looking at. And here's why it's important in this case. First of all, in voir dire, Mr. De La Rionda made a big deal, a really big deal, about direct evidence and circumstantial evidence. Getting the jurors to agree and to understand and to basically say, okay, circumstantial evidence is just as good as direct evidence. And we know it's not, actually. It's not as good as direct evidence unless it meets the conditions or the criteria set forth here in this special instruction that this jury would have to apply in this case. It must be, those circumstances themselves have to be proved beyond a reasonable doubt. The jury needs to know that when you're comparing circumstantial evidence versus direct evidence. They need to know from this court that the circumstances must be consistent with guilt and inconsistent with innocence, meaning if they have a fact that's circumstantial, that tends to prove something the state is claiming it supports, or it could be interpreted as establishing a doubt or something that the defense claims exists, then the jury needs to know that if they have to decide how to interpret that piece of circumstantial evidence, that before they can use it against Mr. Zimmerman, they have to believe that it is only consistent with guilt and could not be consistent with innocence. In other words, Mr. Zimmerman gets the benefit of that issue, whether or not it's consistent with guilt or innocence. They must find it, in that instance, consistent with innocence and give Mr. Zimmerman the benefit of it. And, of course, that when you connect up the dots, if you will, when you pile on all of these circumstances, they must be so conclusive that it can only indicate proof beyond a reasonable doubt of the guilt. If the circumstances are susceptible of two reasonable constructions, one indicating guilt, the other innocence, you must accept that construction indicating evidence. So indeed, of the circumstances of this case, which is all circumstantial, if you will, on the issue of intent, and frankly, a lot of it is circumstantial on the core issue of self-defense, even though Mr. Root said that George Zimmerman's conduct was objectively reasonable under the information that he had. The jury has to find was his fear. Did he reasonably believe that he was facing imminent great bodily harm or death if he didn't respond with force? They're going to have to get inside George Zimmerman's head. They're going to have to take what was going on in his head under those circumstances, apply it to their own common sense, to their own somewhat objective standard of what's reasonable and what isn't, and come up with a decision based on circumstantial evidence whether under those circumstances it was reasonable, after being hit in the nose, after having his head smashed on the concrete several times and being held down on his back, whether it was reasonable for him to have responded to that force in the manner he did. So there is no other instruction, I think, that's as specific, as poignant, as appropriate to help the jury define how to help the jury analyze the evidence in this case than this particular instruction. It could not be said to confuse the jury. In fact, it gives them the guidance that they desperately need in a case just like this one. So, of course, while the court has discretion, the discretion should be exercised here to give this instruction. It's perfectly proper.
Judge, if that argument were correct, every case with a single bit of circumstantial evidence in it would get this instruction because there is some circumstantial evidence involved. Number one, that's not true. It's not the law, and it's the reason it was abandoned 30-some years ago and hasn't been given. I don't see a case relied upon by the defense here where it has been. Number two, this is, of course, not a totally circumstantial case because we have direct evidence in the form of the defendant's own statements, and there is direct evidence that the defendant shot and killed the victim. So there is no question that this is not a totally circumstantial case, which is, I would put it, the only way we even get close to thinking about giving this instruction. And if the defense's argument were correct, this instruction would be continued to be given every case where there is a single bit of circumstantial evidence. It's just not. And it's not for the reasons that are expressed in the Wadman case. Because it is confusing and incorrect. So, that's what the Supreme Court said about it. The fact that the Supreme Court has said, just like with any other special instruction, there are going to be cases where a court may think it is appropriate to give this, doesn't mean what Mr. West thinks it means. The Supreme Court prefaces every jury instruction opinion they issue with the idea that the court isn't saying this isn't ironclad forever that we'll never change our mind. Montgomery is a classic example.
Okay, I've heard enough argument.
Yes, Your Honor.
I'm not going to give the circumstantial evidence instruction. The next one in our packet was the plea of not guilty, reasonable doubt, and burden of proof, and yesterday there was an indication that neither side objected to that. Is that correct?
That's correct. This is a standard instruction.
Okay, and the next one was the date of the crime, and yesterday there was no objection to that instruction. Is that correct?
That's true.
The next one was venue. There was no objection yesterday as to that instruction. Is that correct?
Yes.
Weighing the evidence, yesterday we had discussed the 1 through 5 that are always given. The state had requested the one on inconsistent statement. Court indicated it would be given. It appears in the new one the state is also requesting the instruction that whether the witness has been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify. Is there any objection by the defense?
It's my understanding that the state wants this because there has been some testimony that experts have charged money for their services, as opposed to suggesting that someone has been paid off or bribed in some way. Is that the focus of it?
It is that, whether the compensation was financial already or expected. I think Mr. Root said he hadn't finished a bill yet or something of that variety. But yes, that is the reason. Nobody's going to be suggesting anybody was bribed. But there was compensation.
Well, that's kind of an interesting issue because there were some witnesses who were asked or indicated that they, I hate to use this word, but some people sounded like they were giving infomercials. And I don't want this to be construed that the jury can consider that. I think it would be misleading in that context.
I understand.
Because what the intent of any of them to give that additional information doesn't have anything to do with the defense calling that person or the state calling that person.
I understood. Dr. DeMaio, for example, is one expert that comes to mind. He actually had listed the exact amount that he was paid for his work and to be
Well, there's a special instruction given for expert witnesses that I think that is appropriate to cover this. I could see the danger of this one because of that
Just for clarification.
possible infomercial information out there, so I'm not going to give it.
Thank you, Judge. Just for clarification, unless to be argued later, Dr. DeMaio has not been paid anything. He said what he was charging.
Well, experts are entitled to be paid.
Absolutely.
So we're not going to give that number 6, so redo that the number 6 will be the inconsistent statement.
Yes, Your
Was there anything else about the weighing the evidence that either side had any objections with?
No, Your Honor, not from the state.
From the defense?
Okay.
The next one was the expert witness instruction, and yesterday there was an indication there was no objection from either side. Does that remain?
Yes, Your Honor.
Yes.
Defendant testifying, we said was not going to be given. The defendant not testifying, is there any objections to that instruction?
No objection.
State?
Not from the state, Your Honor.
Defendant's statements, yesterday there was an indication there was no objection to that instruction being given. Is that the same today?
It is from the state.
Mr. West,
Yeah,
you don't have to keep jumping up and down. You can remain seated.
Thank you.
You're
Judge.
welcome.
I just caught something here, whether we're going to personalize these instructions too.
All of them.
Okay.
Everything will be conformity.
Yes. No objection.
Rules for deliberation, yesterday there was an indication there was no objections to this instruction. Does that remain the same today?
Yes, Your Honor.
Your Honor, if I may, as to the substitution of the names, do you want that in the title too? For example, the defendant's statements, the title
Everywhere.
of that, you want that to say George Zimmerman's statements?
Yes.
Yes, Your Honor.
Thank you. Then the instruction on notes, the indication yesterday there was no objections. Does that remain the same?
Yes, Your Honor.
Yes, Your Honor.
Cautionary instruction, no objections yesterday. Does that remain the same?
Yes, Your Honor.
Verdict, there was no objections yesterday. Does that remain the same?
Yes, Your Honor.
Defense?
Yes, that's fine.
Okay. And submitting the case to the jury, there was no objections yesterday. Does that remain the same?
Yes, Your Honor.
Agreed?
Okay. We have to talk about the felony murder, third degree. One of the elements for felony murder or the child abuse portion of the felony murder
Yes, Your Honor.
is the intentionally. I'm having an initial issue with that. Child abuse requires the defendant to have committed an intentional act.
Yes.
That's not alleged in your information.
Shooting is an intentional act. It's the same intent required for second-degree murder. Second-degree murder requires the additional depraved mind element, but I don't think it's argued that this was an unintentional shooting. The question is whether it was justifiable, but not whether it was intentional.
That's the issue that I'm going to be looking at. I'm going to give Mr. West some time to do that. The other Was there any objections to the manslaughter instruction as it is written?
No.
So the only one that I have to deal with and make a determination on is the felony third-degree murder. Can we then now look to the proposed verdict form?
Judge,
With regard to the third-degree murder issue, Judge, of course, the court pointed out it's one of those historically Category 2, which means that it's discretionary so long as the evidence...
The state gets it if they want it, if the facts fit to it. It's not really a discretionary issue.
I disagree, but...
Okay, well, I'll cite you to, I think it's Johnson versus State.
In any event, I'll look at that.
I want to make sure I give you the right citation.
But it's clear that the state must convince the court that the unique facts of this
Of
case...
course, always the facts have to fit into it, and that's not the issue.
Would-
The issue is whether or not, if the facts fit into it, do they get a second Category 2 instruction?
there is the state's proposed special jury instruction regarding the definition of great bodily harm as well before we get to the verdict forms.
I'm sorry.
My understanding is the defense objects to that in its entirety, and obviously I don't intend to place it, if it is given, at the end, but we could discuss placement if we wish, if the court is going
Okay.
to permit it.
Let's get on the record to make sure. It states proposed special jury instruction number 1, defining great bodily harm, setting the authority of Chesnoff versus State, 840 Southern 2nd, 423, 50 CA 2003. The suggested instruction reads, great bodily harm in the context of aggravated battery means great harm is distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises as are likely to be inflicted in a simple assault and battery. That would be if the court was giving the instruction on the justifiable use of deadly force that included the force of a felony being inflicted on the defendant. Is that correct?
Well, I don't agree necessarily just to that. I would agree that if the court is not going to give the issue about aggravated battery, that we might remove the phrase of aggravated battery. However, even the requested instruction by the defense discusses the concept of in fear of imminent death or great bodily harm. So I think the definition and the concept behind Chesnoff and Coronado and Gordon and Owens, all those cases cited here, is defining great bodily harm so that the jury has a frame of reference. So whether the court gives the state's requested additional instruction or only the defendant's
Let me see
instruction.
if I'm getting what you say right. You would take out in the context of aggravated battery
Yes.
and then put it in the defendant's version of justifiable use of deadly force after the paragraph, a person is justified in using deadly force if he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself?
That would be a reasonable location, yes, Your Honor.
Okay. Any objections?
Yes.
What is your objection?
Well, there are multiple. First of all, the context of the cases cited is not appropriate for the context of the definition the state seeks in this case. There is no definition in the justifiable use of deadly force instruction for a reason, because the Supreme Court decided it didn't need to be defined beyond that within the common understanding of those terms by the jury. The state is seeking to shift the focus away from what everybody knows is great bodily harm and why that's in the instruction. And the reason it's in the instruction is this: it's not that Mr. Zimmerman sustained great bodily harm or great bodily injury himself. That is a completely irrelevant issue in this case.
Where in your proposed instruction does it have a definition of great bodily harm?
It doesn't. I gave the language that the Supreme Court used. That's the standard instruction. The Supreme Court does not define great bodily harm in the standard instruction for justifiable use of deadly force.
But the state is saying that this authority, Chestnut versus State, as previously cited, Coronado versus State, 654 Southern 2nd, 1267, Florida 2nd, DCA 1995, Gordon versus State, 36 Florida Law Weekly, D 2590, Florida 3rd, DCA 2011, which cites to Owens versus State, 289 Southern 2nd, 472, 2nd DCA 1974, and C period A period C period versus State, 771 Southern 2nd, 1261, 2nd DCA 2000, and when NGUYEN versus State, 858 Southern 2nd, 1259, 1st DCA 2003.
Has the court read those cases?
I just see the synopsis. I do not have those cases.
And the synopsis is the one provided by the state?
Correct.
Yes, and it's not correct.
It's actually a quote, so.
No, these aren't self-defense cases. These cases don't deal with the definition of great bodily harm in the context of the self-defense instruction. For example, in Chesnoff, the 14-year-old victim was attacked by another, and he was punched, I guess, and kicked, and that he had swollen lips and a swollen head, so swollen that his mother didn't recognize him the next morning. The jury got the instruction of basically severe harm or great bodily harm, and the jury found Mr. Chesnoff guilty of that offense, based upon the very thing that Mr. Manti suggests should be trivialized in this case. That is misleading and not appropriate in this case. Likewise, to suggest to this jury by any definition of great bodily harm like this one, which frankly is legally wrong and we object, would shift the focus of this jury not from what Mr. Zimmerman thought was happening, which is the standard the jury should apply, but to what actually happened to him. And it's a mischaracterization of the law, it's misleading, and this is just plain wrong for the jury to have, factually and legally. As the court is well aware, there are no injuries required whatsoever for self-defense. Mr. Martin didn't have to lay a hand on him if, indeed, Mr. Zimmerman reasonably believed that the use of deadly force was necessary to prevent the imminent commission of great bodily harm. Everybody knows what great bodily harm means when you're punched in the face and your head is smashed on concrete. The state's expert said there are at least 3 impacts on concrete by Mr. Zimmerman's head. That is Dr. Valerie Rao. There's no issue there. She said as much. She saw the bruising, the collection of blood under the skin. She saw the lacerations. Dr. DeMaio opined further, having seen additional injuries, further increasing the number of the minimum times that Mr. Zimmerman's head would have impacted concrete. What the state has been trying to do from the beginning is somehow shift this not to what somebody going through what Mr. Zimmerman was going through at the moment must have felt that when you have your head banged against concrete and you're screaming for help and the person beating you doesn't stop and no one's coming to help, that's a reasonable basis to believe that you're facing great bodily harm. Just because he didn't die, just because his skull wasn't fractured, just because he healed up relatively quickly doesn't mean that he didn't have that fear and that reasonable belief at the moment. The state is asking the court to deviate from the jury instructions with something specific that doesn't apply, that's not an accurate statement of the law or a definition that has been approved in self-defense cases. This is treading on very thin ice for this court. Very thin ice for the court under these circumstances to instruct this jury on something that just isn't the law.
Response?
Actually, as
disagree. The standard jury instructions for any offense, self-defense, aggravated battery, anything, there is no definition anywhere. That's the reason the courts have given it. Self-defense isn't sort of some special circumstance. The fact is, the phrase great bodily harm is used in an instruction, whether it's in the self-defense instruction or whether it's in connection with another instruction isn't the point. The point is the court said, Chesnoff and Coronado and all these courts said, the standard jury instructions provide no definition of great bodily harm. And that's anywhere. That is the reason they approved the court giving the jury some guidance as to what that might be. I will first point out that Mr. West is not correct that any doctor said injury X must have come from getting your head, I think as he put it, hit on the concrete or mashed on the concrete. What they said was it is possible, it is consistent with that happen, it is equally consistent with getting struck by any hard object, including a fist.
No.
Please don't interrupt each other. But I'm going to interrupt.
Yes.
You have to take each of these proposed jury instructions and the special instructions that are being requested by either side and weave it into what the evidence shows so the jury can be instructed. Your argument that you just provided to me has two different sides of the story. That's the jury can decide which one they believe, whether the injuries were consistent or they were not consistent. The instruction that you're seeking to have entered says that great bodily harm is distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises as are likely to be inflicted in a simple assault and battery. The testimony before the court, whether the jury chooses to believe it or not, that's their purview, is that you don't have to have any injury to be in fear to the extent of the justifiable use of deadly force.
I agree with everything the court said, and that's why the argument wasn't quite finished. What we're talking about here is the defendant's reasonableness of his fear. If his fear is only that he's going to get a fist beating, for example, that is something that the jury should know in relationship to the definition of great bodily harm. In other words,
I find this definition akin to what I've just stricken from the defense request, that they want me to instruct them that the Florida law is it's not illegal to follow somebody. I find this akin to that. So I understand your argument. You have it all on the record. I've cited the cases that you cited to me in support of them. They're on the record. Unless you have further argument about that, I'm ready to roll.
Well, especially, the only further argument I'll make on it is this, especially since I believe that we should include the aggravated battery sections as it relates before, especially since I think those should also be included. Most certainly, this definition should be included,
Okay.
Judge.
Well, I've already struck those, so that's not an issue. Okay, the court is not going to give that special instruction. So is there any other special instructions being requested by the state? Additions, omissions, anything?
The only other one was the provocation instruction under Johnson, where, because there's evidence in the record that Johnson may have initially provoked, that should be given. But those were the two, I think, that the state was requesting here, and then the aggravated battery definition.
Okay.
That was it.
How about by the defense? Right, can we go on to the verdict form? Of course, the verdict form may need to be readdressed because of pending the court's ruling on the third-degree felony murder.
I don't have a copy in front of me, Judge, sorry.
Do you have an extra copy?
Let me try to find it, Judge, but yes, I'm
Are these the same that were submitted earlier?
yes.
It was the electronic version submitted this morning.
Oh, I mean, before today.
Well, no, one of them is third degree.
All right, if I could have a set then of
Yes,
the
you may.
current ones. Thanks.
Have you had an opportunity to review it?
Yes. It's a single verdict form that contains all of the possibilities.
Okay, so depending upon what the court's ruling is on the third-degree felony murder, you think that this verdict form is correct?
I don't like the form of it, and I have some requests in that regard, but I think legally it has the considerations that the jury must address if they find an offense to have been committed and that a firearm was used. Yes.
Okay, then what is your objection to the form? Because it's really not formatted correctly pending the court's ruling on third-degree felony murder and because there's breaks in it.
I understand, but if the court were to say that you're not giving third-degree felony murder, we would simply remove the middle page altogether, I think, and then it would...
Right, so then what would be your objection to the form?
The verdict form is confusing. It's confusing because of the way that it's formatted. For example, it starts with, "We, the jury, find the defendant guilty of murder in the second degree as charged," and then goes all the way through the individual enhancements, if you will.
I have to agree with the defense on this because every time I give this jury verdict form, we have the enhancements as a separate special finding. It could be after the defendant is found not guilty, you could say if you find the defendant guilty of the offense of murder in the second degree, you must further find, and do it that way, because I think there is a lot to get to before you get through the possible findings by the jury as to guilt or not guilt or guilt of a lesser included.
We can do that. The only...
Okay. Is that what your objection is?
Yes,
There
the
should be a
first line
special
can
finding.
say, "We find the defendant guilty of murder," and then
I
the second
understand.
line should say, "We find the defendant not guilty."
No,
And
it
then-
should, no, the way it should say, "We find the defendant guilty of murder in the second degree as charged in the information. We, the jury, if I so find, we, the jury, find the defendant guilty of third-degree felony murder, a lesser included offense." The next line would be, "We, the jury, find the defendant guilty of manslaughter, a lesser included offense," and then it should be, "We, the jury, find the defendant not guilty." That is how it has always been done by this court. Then there should be a section after that that says special findings, and the special findings should be the relating to the firearm. So that's...
I want not guilty on the first page.
I know you want that, and every
And-
defense attorney does, but it's not done.
Well, I'd like it in this case because all of the choices the jury has before they even see the place that says not guilty.
It'll all be on the
There-
same page.
Pardon me?
I understand your argument, but I'm not doing that.
And I think the order of the possible verdicts is also incorrect.
Okay,
So I'd like the court to address this, and that is that manslaughter is a Category 1, third-degree murder is a Category 2. So the logical choice would be, if the court's going to give those lessers, that the first one be murder, the second one be manslaughter, the third one be third-degree murder.
okay, is there any objection to that by the state?
No, we'll do
Okay.
it that way, that's fine. The only issue with that is we will then have to repeat, because the firearm findings for each of the murder counts are different than the firearm findings for manslaughter because of the 1020 life language. Now you're going to,
1020 life doesn't apply to third-degree murder.
that's why
It does
Yes,
too.
yes, it does.
It even applies to aggravated assault.
yes.
Well, I'll have to,
It does apply. You'll just have to put it in a way that would make sense, but the court's
We can do
ruling
that.
is going to be the charges be first, and then the special finding by the jury. Before we recess for lunch, let me give you a schedule thing. Yesterday, Mr. West, you had indicated, or I don't know if it was Mr. O'Mara, I'm getting into a housekeeping issue. You had sought to introduce into evidence Defense Exhibit Double D, and that was the portion of a tape played in front of Ms. Gentile. And the court had indicated that my notes reflected that that tape was played to Ms. Gentile outside the presence of the jury. And I asked the court reporter to check her notes, and the email that I got back was, in cross-examination immediately after lunch, Mr. West asked questions regarding the, quote, "you want that too," end quote, part of the tape, and that was played to Ms. Gentile outside the presence of the jury. When the jury was brought back into the courtroom, Mr. West used the transcript to question her on that issue. So the court will not be admitting Double D into evidence that was not played in front of the jury. As far as scheduling purposes goes, I know the jury is supposed to be back at 1. I know that Mr. De La Rianda wants to get the jury instructions settled before he does his closing argument. I'm going to say that we'll be in recess until 1 o'clock. I will take up the second-degree murder argument, and thereafter Mr. De La Rianda will be given some moments to get his, but that would be the only thing he would have to plug into his closing argument, and we'll start the closing arguments for the state this afternoon.
I'm sorry, the third-degree murder argument, Your Honor?
The third degree, I'm sorry.
Thank you.
Manslaughter will be given.
Who's taking responsibility for finalizing the set of instructions?
Well, the state's going to do it,
Done as we speak, Your Honor.
All right, and
and we'll review them.
Okay.
Okay?
And,
So we'll be back at 1 o'clock and be prepared to argue the third-degree murder instruction. I think all the other instructions have been resolved.
I will do my best. It's only an hour, and as I mentioned, this was all put on us this morning. I knew nothing about it.
I
Okay.
understand.
And will we have a chance to review the verdict form prior to?
Yes.
And is the state going to prepare the draft of it?
Yes, they are.
Thank you, Judge.
Would
Okay.
everyone like that electronically over the break as soon as it's completed?
I'll just take a hard copy.
Yes, Your Honor?
Thank you. Court will be in recess.